Committee on Oversight and Government Reform will come to order. Without objection, the Chair is authorized to declare a recess at any time. Thank you all for being here. This is today's modern age. This is a new phenomenon, new waters, new areas that we're chartering here, and these technological advances, particularly with smartphones, have made it easier to solve crimes and to take criminals off the streets. But it also makes it easier and less expensive for law enforcement to track people's movements over long periods of time. And keep in mind, as we address these issues with law enforcement, there are also issues that bleed over in how organized crime, how individuals can use these types of technologies in a very nefarious way as well. But these advances make it possible to conduct either historical or real-time prolonged surveillance previously unachievable with traditional surveillance techniques. Prolonged surveillance of geolocation reveals intimate personal details far exceeding mere location. As the D.C. Circuit noted, quote, "A person who knows all of another's travels can deduce whether he is a weekly churchgoer, a heavy drinker, a regular at the gym, an unfaithful husband, an outpatient receiving medical treatment, an associate of particular individuals or political groups, and not just one such fact about a person, but all such facts, period," or end quote. Geolocation is more than just a record of where we are or were. It is a window into who we are. Do you want your Uber trip records to have Fourth Amendment protection? What about your Fitbit data? What about your smartphone information? The Department of Justice takes an interesting position on this. The Director of National Intelligence recently acknowledged that, quote, "In the future, intelligence services might use the Internet of Things for identification, surveillance, monitoring, location tracking, and targeting for recruitment or to gain access to networks or use credentials," end quote. In plain English, he's saying that the government intends to appropriate the technology you buy and conscript the companies you entrust with your data to be the arms of the state to spy on you. It doesn't seem like too much to ask the executive branch that before prying into your life, it at least convince a neutral judge they have probable cause for doing so. Protection against unreasonable government searches is a cornerstone of our democracy. It's an expectation in our life. I do believe that each American has an expectation and a right to privacy. The Fourth Amendment provides, quote, "the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated," end quote. Think about what you keep on your smartphone, everything from banking information and personal health data, sensitive communications, family photos, and who knows what in the future. It sounds a lot like persons, houses, papers, and effects to me. In April of 2014, the committee began an investigation into law enforcement's use of cell site simulators after press reports alleged widespread use of devices, also known as stingrays, to locate people. That being using the word stingray in a generic term, there are lots of other brand names that are out there. The committee discovered multiple executive branch agencies possessing these devices, with the Department of Justice alone possessing hundreds of these devices. Even the IRS has a stingray. The IRS. What in the world are they doing with that machine? I do not trust Commissioner Koskinen and the IRS with this technology, especially after the agency targeted individuals for their political beliefs. The committee's investigation confirmed, as many suspected, that law enforcement was using these devices without first obtaining a warrant. And the Supreme Court agrees. In Jones versus the United States, the Supreme Court unanimously rejected the government's warrantless use of a GPS device. In that case, Justice Alito remarked that Congress should solve these issues legislatively, and I happen to agree with that. One of our witnesses here today worked with law enforcement and privacy advocates in his state of Virginia to update Virginia's laws post-Jones to ensure they adhere to the Fourth Amendment and gave law enforcement the legal tools necessary to catch and prosecute bad guys and women in this digital age. My home state of Utah has done the same, as has California. It's time for Congress to follow the lead. I happen to have introduced H.R. 491, the Geolocation, Privacy, and Surveillance Act, in a bipartisan way, in a bicameral way, with a good leadership there in the Senate in a bipartisan way as well. It provides law enforcement clear legal guidelines when and how to use geolocation information, how it can be collected, addressed, and used. I intend to pursue all opportunities I can to make our fellow members and the public aware of this type of technology and what it can mean in your life. We're going to hear a lot today about government rules and protocols, but as Chief Justice John Roberts wrote in a case holding that police need a warrant to search a smartphone after arrest, the founders did not fight a revolution to gain access to government rules and protocols. Just because it's easier in 2016 for law enforcement to track our location and learn intimate details about our lives, it doesn't mean those details are somehow less worthy of constitutional protection. I stand with the founders. Get a warrant. We have a lot to talk about here. In this day and age, not are we look as the Oversight Committee into the past, but I think we also need to look into the future. And a lot of these tools can be used in a good way to make people's lives better. But we also have to make sure on what sort of privacy we're giving up in the name of security. We had a good hearing yesterday in Judiciary talking about with the Director of the FBI, talking about a similar type of technologies and what we're going to do or not do with encryption. But dealing with geolocation is something that we want to explore here today, and we have a good, healthy panel for that. So I'd now like to recognize our ranking member, Mr. Cummings of Maryland.
Thank you very much, Mr. Chairman, and I welcome all of our witnesses today. Today's hearing provides an opportunity to discuss both the privacy concerns and law enforcement interests in obtaining geolocation information about our constituents. Geolocation information provides tracking capabilities with great accuracy, making it a valuable law enforcement tool. This information can reveal intimate details of a person's life, which raises significant concern about whether the American people have a right to expect that information, their private information, be treated as such. It is important that our law enforcement authorities have the ability to carry out their public safety duties, and it is also important that we protect the privacy rights of American citizens. Currently, federal law enforcement officials use authority under the Stored Communications Act to obtain location records from wireless service providers. This law requires law enforcement authorities to provide, and I quote, specific and articulable facts, end of quote, demonstrating, quote, reasonable grounds, end of quote, to believe that the information they seek is, quote, relevant and material to an ongoing criminal investigation, end of quote. Right now, there's a split among federal courts. Some have held that the Americans have a reasonable expectation of privacy over this type of information. They require law enforcement to obtain a search warrant based on probable cause. Others have held that Americans do not have a reasonable expectation of privacy because they voluntarily use their cell phones in this manner. These courts require law enforcement to obtain a court order under the lower standard of reasonable suspicion. This is a legitimate and challenging issue with reasonable voices on both sides. For example, on the one hand, the chairman has a bill that would create a uniform standard, would recognize this privacy interest, and would require law enforcement to obtain warrants based upon probable cause. There are strong benefits to this approach, and it is supported by Senator Wyden, Ranking Member Conyers, and our own Congressman Welch. There are also voices on the other side. For example, Congressman Gowdy has expressed concern that this approach could impair the efforts of law enforcement authorities to investigate and solve crimes. Today, I welcome this debate because I want to make sure that we're striking the right balance. I look forward to hearing from all of our witnesses to help us continue to inform this debate and to ensure that we help our law enforcement authorities while protecting the privacy rights of our constituents. And with that, I yield back.
Thank the gentleman. We'll hold the record open for 5 legislative days for any members who'd like to submit a written statement. And we'll now recognize our panel of witnesses. We're pleased to welcome Mr. Richard Downing, Acting Assistant Attorney General in the Criminal Division at the United States Department of Justice. Mr. Michael Doucette is the Commonwealth's Attorney in Lynchburg, Virginia. Appreciate your being here today. Mr. Paul Larkin, Jr., Senior Legal Research Fellow for the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. And Ms. Nima Singh Guliani, did I pronounce it right? Guliani, Legislative Counsel for the American Civil Liberties Union. We do appreciate you all being here and your participation today. So if you would please rise and raise your right hand. It is pursuant to committee rules, all witnesses are to be sworn before they testify. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that all witnesses answered in the affirmative. In order to allow time for members to ask questions, we would appreciate your limiting the oral testimony to 5 minutes. Your entire written statement will be made part of the record. Mr. Downey, you're now recognized for 5 minutes.
Thank you very much. Good morning, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. Thank you for the opportunity to appear before you today. I'd like to begin with the facts of a case based on public filings. The United States District Court judge in Jacksonville, Florida, was sitting in his living room one night. A shot from a high-powered rifle shattered his window. He was injured, but thankfully the bullet did not hit him. The police had no eyewitnesses and a very large pool of suspects, including many litigants and defendants who had appeared before the judge. So what did the investigators do? Among other things, they applied for court orders to obtain the cell tower records of the phones of some of the possible suspects. Those records provided a general idea of the location of the phones. This information advanced the investigation and allowed agents to exclude certain innocent people and pursue leads that eventually led to the arrest of the alleged shooter. This case is just one example of the importance of location information to a wide variety of criminal investigations. I should emphasize, however, that there is no single kind of geolocation information. Location information can differ in precision, everything from what country the phone is in to precise GPS measurements of latitude and longitude. Sometimes companies generate location information for their own business purposes, and other times law enforcement may gather the information directly. Sometimes it is generated continuously as a phone moves around. Other times, only when certain events happen, like when a user places a call. The department recognizes the importance of considering individual privacy interests when obtaining different kinds of location information. At the same time, location information plays an important and sometimes pivotal role in our efforts to protect public safety and to seek justice. And it is important to recognize that different kinds of location information implicate different privacy concerns. In the time that I have, it would be impossible to discuss in detail all of the various types of location information. And I would like to mention just 2 types. First, cell site information, and second, information collected by cell site simulators. I recognize that these 2 types of information have confusingly similar names. Cell site information is generated by cellular phone companies. A cell site simulator is equipment operated directly by law enforcement officers. Cell site information consists of business records that wireless carriers routinely collect and maintain as part of providing cellular service. These records identify the towers and sometimes the face of those towers handling communications with a particular device. While not providing pinpoint accuracy, the fact that a tower handled communications with a phone can give an idea of the location of the phone at the time that the communication occurred. Providers collect and maintain cell site records for their own business purposes, such as to repair and improve their networks. This data is collected only periodically when calls and other communications occur, not continually. and courts have found that historical cell site information may be obtained based on a court order under the Electronic Communications Privacy Act, as Congressman Cummins mentioned in his opening. This provision requires the court to find that the government has provided specific and articulable facts, a showing that is substantial, but not quite at the level of probable cause. Historical cell site information can play a critical role at the outset of an investigation when there is not sufficient evidence yet to satisfy a probable cause standard, such as in the shooting that I mentioned earlier. I'd like to turn now to cell site simulators, the equipment owned and operated by police officers. A cell site simulator collects a limited set of signaling information, not the content of communications, from cellular devices in the vicinity of the simulator. It can be used to figure out the location of a suspect's phone. The department recognizes that the collection of precise location information in real time implicates different privacy interests than less precise information generated by a provider for its business purposes. That is why, last September, the department issued a new policy governing the use of cell site simulators in domestic criminal investigations. Under the policy, law enforcement agents now are generally required to obtain a search warrant supported by probable cause before using such a device. In conclusion, I'd like to emphasize that the department is dedicated to ensuring that its policies and practices comply with the law and promote the privacy and civil liberties of individuals while we fulfill our mission to protect the public and to seek justice. Thank you, and I look forward to answering your questions.
Thank you, Mr. Downey. Appreciate it. Mr. Doucette, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, members of the committee, my name is Mike Doucette. I'm the elected Commonwealth's Attorney for the City of Lynchburg, Virginia. I'm also currently a board member of the National District Attorneys Association, the largest association representing the voice of prosecutors around the country. And I appreciate the opportunity to address you today Virginia's perspective on the use of geolocation information and changes made after the decision in United States versus Jones. In response to that decision, Governor Bob McDonnell back in 2012 convened a small group consisting of prosecutors, defense attorneys, and law enforcement to draft a bill to allow for a search warrant specifically for the use of a GPS device. One of the problems with which we had to deal with the use of a GPS device was how to satisfy the particularity requirement for a search warrant when the product of that proposed search is neither in a particular location nor is a particular item. And another problem we had to deal with was providing service of the warrant on the target of that warrant, GPS warrant, without tipping him off that he is under surveillance. It would do no good to serve a copy of a search warrant with its attached affidavit to the person who is to be surveilled and then tell that person to go about his usual suspected criminal activity. Our key concern in drafting this bill was how to issue a search warrant in one particular jurisdiction but to allow it to be valid in any other jurisdiction to which the object, usually an automobile, would travel in the future. For standard search warrants, a search warrant is issued in the jurisdiction in which there is probable cause to believe that the evidence or contraband sought will be located at that static point in time when the warrant is executed. And so to address this issue, we defined use of a tracking device to include the installation, the maintenance, and the monitoring of that particular device. The search warrant is valid for 30 days from issuance. Additional 30-day extensions may only be issued by a circuit court. The installation of the tracking device must be completed within 15 days of the issuance of the warrant, and the device must be removed or disabled within 10 days after the use of the device is ended. Upon issuance of the warrant and the affidavit are automatically sealed by the circuit court. There is a process for unsealing. At the end of the use of that particular GPS search warrant, both the warrant and the affidavit must be served on the owner or possessor within 10 days after the end of that use of that tracking device. And again, 30-day extensions may be granted by the circuit court. In 2014, we anticipated through legislation what we believed United States versus Jones might ultimately lead. And so we amended our state counterpart to 18 U.S.C. 2703 to require a search warrant for the disclosure for up to 30 days of the real-time location data of any electronic device. Exceptions were added to the statute in situations where there is an administrative subpoena in child pornography cases and when there is an emergency circumstance or consent. This specific bill was geared towards the real-time location data of mobile phones, whether through pinging the phone by an electronic communication service or through the use of the phone's internal GPS. While the location of the phone does not necessarily identify the present location of the phone's owner, practical experience tells us that most of the time it does. However, in this bill, we specifically did not include historic cell tower information. We subscribe to the United States Supreme Court's opinions, which stated that an individual enjoys no legitimate expectation of privacy in the information he voluntarily turns over to a third party. But we were also influenced by both the absence of the simultaneous monitoring of a person's present location and the lack of specificity in that location provided by the cell tower information. While GPS can pinpoint location within a few feet, historic cell tower information is far less accurate, with the distances measured within thousands of feet, more or less. The lack of specificity in this technology is based on several factors relating to signal strength, including distance to tower, intervening objects between the towers and the phone, the number of towers in the area, and the number of calls that a particular tower is handling. In 2015, we amended that statute even further to include a requirement for a search warrant before law enforcement could use what is commonly referred to as a stingray, because we had inadvertently left that out of the 2014 legislation. In 2015, there were some bills introduced in the Virginia General Assembly to limit the time period for passive use of automated license plate readers. The bills were ultimately vetoed by the governor and have not been reintroduced, although the patrons have promised to reintroduce those bills in next year's session. And that, in a nutshell, Mr. Chairman, highlights the Virginia legislative efforts in geolocation data and technology and its relationship with the Fourth Amendment for the past 4 years in Virginia, and I look forward for the opportunity to answer any questions.
Thank you. Appreciate it. Mr. Larkin, you're now recognized for 5 minutes.
Mr. Chairman, Mr. Ranking Member, and members of the committee, I want to thank you for the opportunity to try to help you puzzle through this difficult issue. I'm going to make only 3 points. First, current settled Supreme Court case law allows the government to obtain historical cell site or cell location information without a warrant and without any showing of justification or need. It may be that the Supreme Court will change that law, but they've not yet done so, so that's the baseline from which we operate with respect to the Fourth Amendment. You, of course, could go further by statute, but the Fourth Amendment doesn't require you to go further at this point. Second, the technology that the chairman mentioned, stingrays, are a new development that allow law enforcement to obtain this information without going through a carrier. The problem, however, is the way the device works. As I understand it, the device works by capturing all the cell phone signals within a radius of the operating device. The effect, therefore, is to shut off those other cell phones of everyone else who is within that radius. One of the problems in this regard is we don't know exactly how these devices work. And I think before deciding whether or not to regulate, that is an important factor that I think the committee has to take up the responsibility for learning. Third, any legislation will require this committee or any other to draw arbitrary lines. But some arbitrary lines are better or worse than others. In my written statement, I've recommended several arbitrary lines that the committee, I think, should consider avoiding, and several others that I think the committee should consider endorsing. At the end of the day, however, in deciding whether to regulate any law enforcement practice, you have to ask yourself several questions. What are the benefits and harms of this practice? What is the likelihood of those benefits and harms coming to fruition? Who are the people that you're going to regulate? That is, do the police officers you're thinking about more closely resemble Joe Friday or Judge Dredd? Finally, what is the risk the public has to accept that you may be wrong in answering all of these questions? Thank you for the opportunity to make a statement and prepare a written one. I'm glad to answer any questions you may have.
Thank you. Ms. Guliani, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, and members of the committee, thank you for the opportunity to testify today on behalf of the American Civil Liberties Union. In today's world, law enforcement can easily and inexpensively track virtually any American who owns a cell phone. GPS chips embedded into our phones provide real-time, precise information about our every movement. Meanwhile, phone companies keep historical records that log information about our phone's location every time we make or receive a call, make or receive a text, or even receive a weather alert. These advances have provided law enforcement with a powerful new surveillance tool that they routinely use. For example, in 2015, AT&T received over 76,000 requests for cell phone location information. Over 58,000 of these requests were for historical information, which the company keeps for a period of 5 years. Unfortunately, our federal law has not kept pace with these technological realities. As a result, law enforcement officials and the public have been left to interpret a patchwork of state laws, conflicting legal precedent, and non-binding policies to determine what policies apply. This mosaic of standards has resulted in law enforcement officials routinely accessing location information without a warrant. For example, in one case in Baltimore, police collected over 7 months of historical location information without a warrant. This information allowed police to infer that an individual was likely at his pregnant wife's OBGYN at some point during this period. In another case in Michigan, police collected over 6 months of location information without a warrant. The Department of Justice has taken the position that a probable cause warrant is not required for these types of collection. The ACLU disagrees with the government's position in this case. The Supreme Court's decision in Jones makes clear that the Fourth Amendment requires a probable cause warrant to collect historical or real-time location information. In her concurrence in the Jones opinion, Justice Sotomayor emphasized the intimate nature of information that might be collected by GPS surveillance, including trips to the psychiatrist, trips to an AIDS treatment center, church, or even trips to a strip club. In that same case, Justice Alito noted that society's expectation has been that law enforcement agents others would not and could not, quote, secretly monitor and catalog every single movement of an individual's card for a very long period of time. Due in part to these concerns, a majority of justices in the Jones case found that long-term GPS tracking impinged on expectations of privacy. More recently, the Supreme Court has expressed concern that cell phone location data can, quote, reconstruct someone's specific movements down to the minute, not only about town, but also within a particular building. Thus, what we're seeing is often a gap between law enforcement practices on one hand, and on the other hand, the sensitivity with which Americans and the Supreme Court view our location information. The ACLU urges Congress and the Department of Justice to take 3 steps to address this gap. Number 1, the ACLU urges Congress to pass legislation, such as the Geolocation, Surveillance, and Privacy Act introduced by Chairman Chaffetz, that would require police to get a warrant before accessing location information. This bill takes a sensible approach. It will require police to follow the same procedures they follow when collecting a variety of sensitive information. At the same time, it preserves the ability of law enforcement to act without a warrant in truly exigent circumstances. This bill also reflects the approach that states like Utah, New Hampshire, and Montana have already taken. Number 2, until such legislation is passed, the ACLU urges the committee to continue to press the Department of Justice to fully disclose its interpretation of the Supreme Court's Jones decision and any associated guidance. The public and members of Congress should not be left in the dark about these important issues. By withholding this information, the DOJ has cut off the robust public debate and oversight that this issue demands. Number 3, we urge the committee to press the Department of Justice to adopt and publicly release a policy that requires a probable cause warrant to obtain real-time or historical information. Last year, the Department of Justice released guidance on stingrays, demonstrating that it can operate under a warrant standard and release information about its policies without compromising investigations. These actions are obviously not a substitute for legislation, but they are necessary to protect the rights of Americans. Thank you again for the opportunity to testify today, and I look forward to answering any questions that you may have on these important issues.
Thank you all for your testimony. I'd like to enter into a colloquy with Mr. Cummings here prior to our questioning. We had good word from the Department of Justice just within the last 24 hours that they would allow myself and Mr. Cummings, plus we would each allow one staff person to review the post-Jones guidance. Now, while I appreciate that gesture, I need to say that it is frustrating that it has literally taken years to get to this point. I serve on the Crimes Subcommittee within the Judiciary Committee, and I'm the chairman of the Oversight Committee. And thus far, the Department of Justice has refused to allow those of us who serve in Congress to even understand how they're using these types of materials. This is a positive step forward. I appreciate it. But as Ms. Giuliani just pointed out, the public doesn't know what's happening, and we don't know what's happening. I look forward to seeing that information and working with Mr. Cummings on this. Let me yield to Mr. Cummings.
Mr. Chairman, first of all, I agree with you. These issues are very, very important to our committee and the Congress and the American people. And so I'm happy that we could work together with the Department of Justice over its production of Jones memoranda. The Department has agreed to provide us with full access to all of the information we requested with no redactions, and we have agreed to consult closely with the Department going forward. We were able to reach an appropriate balance between legitimate congressional oversight and protecting law enforcement sensitivities. I commend the Department for responding to our concerns, and I commend the Chairman for working through this issue in a very thoughtful way. We did this in a bipartisan manner, and I hope that we can continue this approach on other information requests important to this committee. Congressional oversight is a critical function, and we have to have the cooperation of entities subject to our oversight, whether that is in the public or the private sector. And with that, I'll yield back.
I think the gentleman, I would also want everybody to know that it's not just the Department of Justice that owns, maintains, and operates the cell phone simulators, Stingrays, whatever you want to call them. They're different brand names, different versions of the technology. For instance, the Internal Revenue Service has these machines. They've deployed these machines. How in the world is the Internal Revenue Service using this information? We don't know. So today we're going to be focused much on the Department of Justice, but there are also other parts of government. I will also credit the ACLU for the good work that they did in surveying law enforcement across the country at various levels, whether it be state, county, or municipal. There are lots of machines that are out there and available in other law enforcement situations that are not focused at the federal level at the Department of Justice. And so the use of that type of information is more pervasive than just at the federal level. And finally, I would remind members that you can go on the web and buy these machines. So don't think that this is just limited to the good guys in law enforcement. I do think we're living in a world and an age where the price point will dramatically decrease, where organized crime, somebody with nefarious intent, some punk, whatever, is going to go out there and want to be able to use this type of information to gather information about somebody's geolocation and then be able to track that person back and then go find them with such specificity that if you were in New York City, as was mentioned, you could tell not only that they're on a certain block, but you could tell which floor they're on and which apartment they're in or which office they're in. That's some pretty scary stuff. And that's something that I think we have to also consider. So with that as the backdrop, and I appreciate the colloquy, let's go to the questions. I'm going to recognize myself first, and we'll start here with Mr. Downing. And I do appreciate you being here. I really do. These are tough, difficult questions. I still struggle with how the Department of Justice considers geolocation. Is it metadata, or is it content? Because the district court ruled that it said that it's content. How does the Department of Justice view this information?
Thanks very much for the question. That's, I think, the interesting and tricky thing about this label that we've placed on it as geolocation data, because it can come in very many different forms. At times, I would say that it is metadata. That is, it is not the content of a communication, but simply information about the location of where a phone is. But if you think broadly about the way that location information can be stored, if I send an email to my mom and say, I'm at the office, well, that's actually location information, and it's in that form, the content. That might also be true, for example, if I were to post a photograph on Facebook that contains information, that might be part of that photograph and therefore content.
But you do, does the Department of Justice believe that if it knew I was at the hospital, at an oncology department, isn't that the content of my life? And then I move from there to somewhere else. Why is that not content? You think that that's simply the metadata?
So the general construct is the content of the communication versus information about a communication. That's the general way that we look at these kinds of questions. If I were to place a call using my landline phone, the number that I dialed would widely be considered metadata. But the fact that I'm calling Home Depot gives an idea about what I might be talking about. But it's still metadata, even though it can be used to infer certain things.
And this is where I think I beg to differ. I think geolocation, certainly used for more than just a split-second snapshot in time, even if it was, you can tell a lot about what they're doing. If I called from the local jail, that's going to provide a lot more information than just the fact that I called Bob. Is there anything that Ms. Giuliani or Mr. Larkin or Mr. Doucette said, Mr. Downing, that you disagree with or you found in their testimonies?
One thing that I think is important to understand is that we often hear discussion about whether something was obtained without a warrant. And of course, that is true, that is the department's position. But it brushes over the idea that when we use a court order under Section 2703 of ECPA, that there are substantial privacy protections built into that it's not that law enforcement is waltzing in and just obtaining it at a whim, but in fact a series of process which requires specific facts to present it to the judge before we can obtain that information. That's one response I would have that I would offer.
Is the IRS doing that?
I don't oversee the IRS, but I do believe that they would be, yes, because...
Why do you believe that?
Because the carriers know what sort of process to expect.
So it's up to AT&T to police the IRS? I mean, you've jumped to a conclusion and an assumption that the IRS is living up to the standard of the Department of Justice. I want to know why you think that is.
Well, I think all law enforcement agents and prosecutors,
But
we
is
seek
the
to
IRS...
follow the law, and the law is that at a minimum you need to obtain this kind of court order to obtain records or other information pertaining to a customer or subscriber. That's the law.
Ms. Giuliani, is that the way you see that?
No, we disagree with the Department of Justice. The standard that is under a 2703D is not a probable cause standard, and we believe that doesn't reflect the intimate nature of location information. It doesn't reflect how Americans view this information. Under polling, 80% of Americans view their location information over time as sensitive. That's a greater percentage than view their relationship history or their religion as sensitive. And the Department of Justice position also doesn't comport with what courts have said about the sensitivity of this information. Courts have recognized that location information over time can tell you whether someone is a regular churchgoer, is an unfaithful husband, is a heavy drinker. And given the intimate nature of this information, we believe that a probable cause standard is the correct standard, as many courts have found.
So the FBI director testified that they do use probable cause, but what about all the rest of the Department of Justice? Do they or do they not, under the description Ms. Giuliani cited there?
I think I would I would go back to the general overarching point here, which is there are many kinds of location information. We certainly do use warrants for cell site information when it's collected by the cell site simulator. We also use warrants when we are collecting precise GPS location from the providers. The difference is, and the courts have supported us in this, when we are obtaining less precise information that is a business record of the carrier, cell site information, then that does not require a warrant, although there are many standards that have to be met that are built in for the protection of the privacy of the individual.
My time has expired, but I do wish you would provide that standard to the public and to the Congress. We're different than most every other country on the planet. I get it, but we do value our privacy too. Ms. Giuliani, I'll let you speak, and then we'll go to the ranking member.
Yeah, I just wanted to address a point of this idea that somehow historical cell site information is not as precise as GPS information. And that doesn't reflect the way technology is moving. We're increasingly seeing this information be very precise because it's not just the tower you connect to, it's the direction, it's the distance. Even in cases people have microcells, so a tower that only serves their home. And given this, the precision of cell site information, historical cell site information, is quite accurate, and I think our the standards that we've used does not reflect that accuracy.
Thank you. I'll recognize the ranking member, Mr. Cummings.
Ms. Giuliani, geolocation information is a critical law enforcement tool, I think you'll agree, but it has significant implications for an individual's privacy rights. We have to balance the need of our law enforcement authorities to access this information with the importance of protecting the privacy rights of American citizens. Cell phones and other wireless communication devices provide location information to service providers each and every time a phone call is placed. Is that correct?
That's correct.
You mentioned the Baltimore case a little bit earlier,
Right.
and you said that apparently they had surveillance for 7 months. Is that what you said?
They had obtained historical cell site information for a period of over 7 months. That's correct.
And what happened in that case?
In that case, police did not obtain a probable cause warrant. They operated under a lower standard, and that case is being challenged.
Now, should individuals have a reasonable expectation of privacy with respect to their location information?
We believe that individuals do have a reasonable expectation of privacy, and that has been reflected in statements from the Supreme Court that have recognized that the Fourth Amendment has always acknowledged that there are facets of American life that should be free from improper government intrusion. And your location, whether you're in your home, whether you're in a church, that those are aspects that should be protected.
Mr. Doucette, geolocation information can be used to provide critical assistance in complicated criminal investigations to apprehend dangerous and violent fugitives or help locate kidnapped children. Can you describe how geolocation information can be useful in these types of complex criminal cases?
Mr. Chairman, Mr. Cummings, we've had a number of cases, especially dealing with historical cell tower information, where we've been able to obtain this particular information through a court order, a 2703 court order. And specifically in one case in Lynchburg, we were able to solve a rather serious homicide where we had no suspects at all. And basically, through the course of doing this particular investigation, developed the estranged son-in-law. But we had no information whatsoever to beat his alibi that he was in Richmond 2 hours away until we were able to get his historical cell tower information through a court order and show that no, at the time that the murder occurred, he was actually in the city of Lynchburg. But that was not enough to get any sort of a conviction. We had to go forward and do a lot of police work afterwards, but again, that led us down the right path and led us through to be able to ultimately bring this person to justice.
You know, when you watch 2020, you find the use of this cell phone information to be extremely helpful in a lot of very, very serious cases, showing where the location of a person was at a certain time, and to kill an alibi, usually. Mr. Dowling, how precise is historical cell site information?
Historical cell site information varies considerably depending on the size of the coverage area of the particular antenna. In rural areas, it tends to be extremely large, a matter of miles perhaps. In urban areas, it tends to be smaller, and in certain cases, may be quite small, down to the level of a much smaller area.
So when you say rural, I mean, can you give me a max, just a general, what, 5 miles, 10 miles, 20 miles?
I don't know the specifics, but it's on the order of, yes, 5 to 10 miles, something like that.
What impact would a search warrant requirement for historical cell site information have on a criminal investigation?
We are troubled by the idea of requiring a probable cause warrant because there are situations like the one I mentioned involving the person shooting at the judge, where we are at an early stage and we do not yet have probable cause, but the ability to gather that sort of information can be very important to follow up on leads, such as Mr. Doucette mentioned, and to exclude people, frankly, that are not involved or that weren't involved in the crime. So that's an important and useful tool, and it should be considered as we debate this question.
Mr. Doucette, do you agree?
Absolutely, sir.
And what impact do you think a search warrant requirement would have on a criminal investigation?
Again, as pointed out by Mr. Downing, a lot of times we're strictly in the investigative stage. It would shut down the investigation completely because we would not have that level of probable cause. We're using this particular information to establish probable cause, not that we already have it.
Mr. Giuliani, a search warrant is not required for physical surveillance of a suspect. Why should a search warrant be required for geolocation information?
The nature of the information we're talking about is quite different from a police officer, for example, following someone. You know, with phone information, the law enforcement can inexpensively and easily track virtually anybody, and it's not constrained by resources as you would normally have in a situation where police are following somebody. But I also want to follow up on this question of, you know, whether a probable cause warrant will interfere with the ability of law enforcement in certain cases. The idea of a warrant for this information is not a novel idea. There have been many states who have passed laws that require a warrant for real-time or historical information, and there's no evidence that, for example, in Utah or in Montana, where such a standard exists, that law enforcement have been stopped from doing their job.
And last but not least, I want to go back to something that the chairman was talking about. I guess he was talking about the stingrays. You know, one of the things that I've always been concerned about, the domestic violence cases, where you have usually a woman who is trying to get away from a dangerous situation. She relocates, trying to hide, really, from danger. And I guess, as he was talking, I was thinking that's a lot of power for somebody who wants to get to her. Is that right, Mr. Doucette? Would you agree?
Absolutely, sir. And we did include, because when we're dealing with real-time location data, such as whether it comes from a cell phone or provider or through a stingray, we do in Virginia require a search warrant because we do have probable cause. And again, you know, if a perpetrator wants to use this, the Fourth Amendment does not deal with him. We're going to have to pass laws, but outside of the realm of the Fourth Amendment, sir.
Thank you very much, Mr. Chairman.
Thank you. Now recognize the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Ms. Giuliani, you're familiar with the stingray technology that the chairman referenced a little bit ago?
Yes.
Yeah, and the fact that it mimics a cell site, tricks phones into going to that so that the person using the stingray can get access to the numbers and therefore where this person, in fact, is located.
That's correct. All phones in range.
And the fact that every major law enforcement agency in the federal government is using that, I assume that troubles you a little bit like it does me?
We were very troubled, specifically by the notion that these devices have been shrouded in secrecy. The public didn't know about them, judges in many cases, defense attorneys.
And did you also know that it wasn't just limited to law enforcement, that it included the Department of Energy and, more importantly, as the chairman pointed out, the Internal Revenue Service? Did you know that?
Yes, there have been recent reports that the IRS and other agencies are also using these devices.
Mr. Downing, did you know the IRS was using the stingray technology?
I believe, I do understand that. It's the criminal part of the IRS, the criminal investigators.
No, but did you know they were using it, or did you learn in the press like the rest of us did?
I personally didn't have specific knowledge of it, no.
Have you, I know you've got this Jones memo that you've given to all law enforcement in the federal government but won't show Congress and therefore the American people. Has the Jones memo went to the Internal Revenue Service to tell them how you think they should use this stingray technology that you didn't know they were using?
No, it did not, to my knowledge.
So you haven't sent it to them? But this is the guideline on how we're supposed to deal with this important privacy issue that you thought was so important that you gave it to everyone in the Justice Department. You won't let Congress see it, but you know an agency has used the technology and you didn't give them the memo, the guidelines on how they should appropriately use it?
We have given them the sell-side policy of...
No, I'm asking about the Jones memo, this secret document that you won't let us see. Has it been given to the Internal Revenue Service? After all, they've used this technology on American people.
The Jones memo is a memo that advises...
Has it went to the Internal Revenue Service?
I don't know the answer to that. I don't believe so.
Well, that's scary, because let me just remind you all something here. The Internal Revenue Service, for a sustained period of time, systematically targeted Americans who were exercising their First Amendment liberties. And they sent questionnaires and information to these, told these groups to answer questions like this. Please provide board member or officers who has run or will run for public office who are in your group. Please provide handouts you provided to the audience participants and to the public. Please provide detailed contents of any speeches given at your meetings, copies of current web pages. They ask them, will you attempt to influence the outcome of specific legislation? That's a fancy way of asking, will you exercise your First Amendment rights? Are you kidding me? And now this same agency has Stingray technology, has used Stingray technology, and you haven't even given them the memo to tell them how they should appropriately use it? This is unbelievable. Give copies of all communications, pamphlets, advertising, copies of any radio, television, internet advertisements you've done. Another 33 questions sent to another Tea Party group. Have you conducted or will you conduct voter education activities? Now, this is amazing. Provide details regarding your relationship with, they list a person's name, Justin Thomas. Now, think about this. All these questions that I think go right to the First Amendment liberties, and now this agency has a technology that they can go into an area where, let's say there's a political rally going on. They go into an area, say, we're gonna trick every cell phone to come into this device so we can get people's phone numbers, know who they are, who they've been talking to, who they associate with. In this context, and you didn't even know about it, and you haven't even advised them on how to use it? Mr. Larkin, is that a little concerning to you?
The predicate facts are very disconcerting, very troubling. One of the lines that I think the committee should consider not drawing is trying to limit the use of these sort of devices by agency, because over time it'll bleed over into every other agency. And that doesn't even begin to count the number of state and local agencies that can use these devices. So there's a very troubling aspect of this problem.
Yeah, it seems to me at a minimum you need a probable cause warrant before you can do this. I mean, again, I think you have to view everything in context. You have to view it within the framework of what we have seen from this administration going after people's First Amendment liberties, people's Fourth Amendment liberties, and now they have this technology that the Internal Revenue Service is using with no guidance from our own Justice Department. I mean, that boggles the mind, boggles the mind. Ms. Giuliani, I'll give you the last word.
Sure. I mean, I would echo the same concerns. We're concerned that the guidance that exists doesn't apply to states and localities or other federal agencies. And I will note even that guidance has loopholes and deficiencies. There's a warrant requirement by default except for exceptional circumstances. Exceptional circumstances aren't defined, and we've had no additional information as to what that even means. So given this and some of the other deficiencies, how are judges informed of this? How are defense attorneys informed of information from these devices being used? There's just no clarity right now. This
Jones memo with guidelines, this secret memo that we can't see, but the night before the hearing they tell the chairman and the ranking member, oh, we'll let you view it in private with your secret 3D glasses or whatever it is, and they won't let the IRS know how they should do this. Unbelievable. I mean, it's true, unbelievable what we're seeing in America today from this Justice Department. I yield back, Mr. Chairman.
Thank you, gentlemen. We now recognize the gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Mr. Chairman. Mr. Downey, you had testified in your oral testimony that these Stingray devices track geolocation, but they don't track content. It's true, however, that these Stingrays can, in fact, be configured to track the content of conversations, correct?
The devices that we use are not configured, nor do they have the necessary software to do that. And if they did, it would be in violation of our policy. But as a general matter, this type of technology could be used in that manner that you suggest.
Could this technology also be configured to track text messages and emails, the contents of those communications as well?
If you had the right software and you configured it and you violated the policy, then yes, you could do that as a...
Is there anything stopping the Department of Justice from changing that policy next month or next year?
No, we have the ability to change the policy.
The IRS has these stingrays. Does your policy apply to them?
It doesn't apply to them directly, but if they were to be used in compliance with the Pen Register statute, then they would need to have a prosecutor, a department employee involved in that.
Does your policy apply to local law enforcement agencies?
It does not apply to local law enforcement agencies.
So these stingrays could, in fact, be used by the IRS or local law enforcement agencies to not just track geolocation, but also the content of communications, including text messages and emails, correct?
If they did it without a wiretap order, then it would likely be a federal criminal offense, but I suppose, yes, anything is possible.
Let's talk about historical data versus real-time tracking. My understanding is the Department of Justice believes that you don't need a warrant to access historical geolocation data, but you do need one for real-time tracking. Am I understanding your position correctly?
We have taken the position publicly that you do not need a warrant for historic cell location information. If we were to use real-time tracking, if what you mean is specific precision GPS location on a prospective basis going forward, we, yes, agree a warrant is required in that circumstance.
So let's say someone has cancer, doesn't want people to know about it. They go to a clinic that just treats cancer. Why would it matter from a privacy perspective whether that person went to that cancer clinic last week, or they're there right now, or they're about to go to it tomorrow? Isn't the privacy interest exactly the same?
The data that would be the basis for historical and prospective that we were just talking about is not identical in its precision, nor is it identical in the way that it's collected. So I'm not sure we're comparing apples and oranges, but of course, whether somebody is being tracked in real time going forward has historically been recognized as something that is more intrusive than looking at a historical view of somebody's activities.
I completely don't understand this distinction. I think it's stupid and meaningless. So, Ms. Giuliani, can you elaborate on that distinction?
We also don't believe that there should be that distinction between historical and real-time data. You know, as one judge put it, the idea that something is less intimate because you're looking at a picture that's already been painted just simply isn't accurate. It's also important to note that courts have recognized that there are areas where you're entitled to enhanced protection, for example, in your own home. And historical data captures whether you're in your home, how often you're in your home, when you leave your home. And given the accuracy of historical data, and we anticipate that it's only going to become more accurate, we believe that it should be treated with the sensitivity it deserves, and a probable cause warrant should apply.
Thank you. Mr. Larkin, what do you think about that distinction?
It depends whether you're talking about it as a matter of law or policy. As a matter of Fourth Amendment law, there's probably no distinction between past data about a person and present data. The Fourth Amendment would not require a search warrant or probable cause in either case. But if you're talking about the effect on privacy, then yes, it can be the same in both cases. See, the Fourth Amendment treats not past and present as the distinction. It makes the distinction in other ways between protected areas and non-protected areas. If you are on a city street, the Fourth Amendment would allow the police to see what you're doing and follow you, whether they've done it 100 times in the past or are doing it now. If you're in your home, that's a protected area and that's different.
Thank you. Mr. Downing, can I see this super secret memo or only the chairman and the ranking member?
Let me say that the department has great respect for the needs of this committee and wants to work towards giving the information that's required. Of course, at times there are going to be situations where the content of documents as the effect of inhibiting the kinds of things that we do, such as by giving criminals warning about the types of activities that we might use to investigate them, and also to reveal the litigating positions of the department, which is an important internal deliberation. All that being said, as the chairman and ranking member announced, we seek an accommodation with the committee to get the committee the information that it needs. And so I understand that our Office of Legislative Affairs has worked out a compromise that we're going to try to pursue at this point.
Mr. Chairman, could I have 15 seconds to respond?
Sure.
I fully trust Chairman Chaffetz and Ranking Member Cummings. I just want to note that the message you're sending to me and other members on this committee is you don't trust us. I find that offensive, disrespectful, and it will affect my dealings with the department and maybe other members here and their dealings with your department on an ongoing basis. And I yield back.
I thank the gentleman. Now recognize the gentleman, Mr. Desjardins from Tennessee, for 5 minutes.
Thank you, Mr. Chairman. Thank you, panel. As you all know, the Fourth Amendment provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. In other words, protection against unreasonable government searches is a fundamental right. Mr. Downing, as the courts have made clear in their rulings, all evidence that is obtained through an unconstitutional search is inadmissible in court. Would this exclude all the tracking information, even the information obtained where the suspect had no reasonable expectation of privacy, like driving on public roads?
So the constitutional suppression would only apply to that information that is indeed protected by the Constitution. So if the court found that the information was not implicating the Fourth Amendment, then constitutional suppression would not apply in that situation.
Okay, so then what are some examples of situations where a warrant would not be necessary when placing a GPS on a vehicle?
There might be situations that come up where there is a life and limb emergency, for example, where the courts have long recognized that the warrant requirement doesn't apply. So, for example, in that situation, law enforcement officers could search a house without a warrant because of the immediate need. Those kinds of exceptions would apply also in the case of tracking devices on vehicles.
Mr. Liu touched on this a bit. What should be the legal standard for historical geolocation information?
Was that question to me or Mr.
Yes,
Doucette?
yes, sir.
I apologize. Historical location information?
Yeah. What should be the legal standard for historical geolocation information? In other words, why would you have less interest or why would you have less privacy interest in where you were last Saturday than where you'll be next Saturday?
So the department's position is that historical cell site information does not require a warrant, and 3 circuit courts have agreed that that's the case. The reason that it is different is that it is less precise in general, that it is a business record collected by the company, that it is not continuous but only recorded when communications occur. And so for all of those reasons, it's a different category of information than, say, real-time GPS information that's collected prospectively. For that reason, the courts have recognized that it does not have a constitutional protection.
How far can law enforcement go back? A year, 3 years, 5 years?
The amount of time that you could go back would all depend entirely on the record collection and retention practices of the company, because these are company records that are not mandated to be stored. It's a choice that the companies make. And so it's variable. Some go back for a short period of time, others for longer.
Ms. Giuliani, would you like to comment on or share your opinion on those issues?
Sure. You know, as I mentioned before, we believe this distinction between real-time and historical information is artificial, not just because of the increasing accuracy of cell site information, but also because of the very real privacy interests that Americans have in protecting the fact that they've been to an AA meeting 6 times in the last week, or the fact that they only sleep at home 5 out of 7 days a week. With regards to historical cell site information and the time period that providers keep that information, in some cases that can be close to 5 years, for example, in AT&T's case. With Sprint, 18 to 24 months. And that's incredibly intimate information about someone's life. And given this, we believe that a probable cause warrant, the same standard that would apply if law enforcement wanted to read a letter of yours, is the correct standard.
Mr. Downey, do you agree with that?
With all due respect, do not agree. The reason that this information is different, first of all, let me say, we respect that it is private information, and we believe that it should be protected. We believe it is protected. The Electronic Communications Privacy Act already creates rules. It's not at a probable cause standard, but nevertheless, it is quite protected and not instantly available to law enforcement whenever it chooses. We have analyzed, though, the constitutional rules here and have taken the position that the Constitution does not require a probable cause standard for the reasons that I explained before.
Ms. Giuliani, do you agree with that?
Respectfully, we disagree, and there are many courts that have recognized that historical information is extremely sensitive. For example, a Fourth Circuit opinion that is awaiting en banc review, where the court found that historical cell site information was sensitive and should be provided a higher standard. I think it is important to note that states across the country have recognized this, have recognized the sensitivity with which Americans view this information, and have on their own adopted, in many cases by nearly unanimous votes in their state legislatures, legislation that protects historical and real-time cell site information. And given this trend, both at a state level and both in terms of the American view of this information, we feel that this is a case where it's ripe for Congress to make clear that this information should be afforded a higher level of protection through legislation and by pressing the Department to change its policies and its position.
Thank you both for your time. I yield back.
Thank the gentleman. We'll now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Chairman Chaffetz. The first thing I want to do is I want to clarify something. It was heard in this room not 10 minutes ago that it was a great revelation about stingrays in use by the IRS. Please do not be misled by that. It was not a revelation this month. This committee was briefed on stingrays back in November 12th, 2015, by Richard Weber, the Chief of the Office of Criminal Investigation, and also has received at least 2 briefings, one in January of this year and one in November from the Department of the Treasury from TIGTA on the use of stingrays. So this, anybody claiming that this is a revelation wasn't showing up for the meetings. I want to talk about geolocation legal standard. Ms. Giuliani, law enforcement currently has the ability to obtain geolocation data through the use of a valid court order. Law enforcement relies on legal authority provided in the Stored Communications Act to obtain an order compelling a service provider to disclose cell site location information. These orders call for specific and articulable facts showing that there are reasonable grounds to believe that the cell site information is relevant and material to an ongoing criminal investigation. There's been disagreement in the federal courts over whether this is the proper standard, and some federal courts have decided that there is an expectation of privacy in cell site location information, and they have imposed stricter requirements for law enforcement to obtain the information. I wanted to ask you, what is the impact of a lack of a uniform standard governing access to geolocation information?
There are very practical impacts. I mean, I think the first and foremost is the reality that many Americans' information may not be adequately protected. So if you happen to live in a state that has not passed a law protecting information, law enforcement may be able to access your information under a lower showing. And I think that, the Supreme Court has recognized, courts have recognized, that the Fourth Amendment is important not just to protect people's privacy, but also for freedom of expression, freedom of association. The idea that law enforcement may be able to track your every movement could chill, the desire of someone to go to a protest, to visit their psychiatrist. And these are very real effects, and the reason why we believe that it's so important that a high standard apply when law enforcement collect this information.
Thank you for that. And I want to shift over to you, Mr. Downey. Do you agree with that?
We do not agree. We think and have taken the position in litigation that it is appropriate to have that lower standard, and that although it is lower than probable cause, it is not a no standard. There is, in fact, a lot of protection that is built into that. The reason that it's particularly important, however, is that, as mentioned before, the early stages of investigation can certainly benefit from the ability to get this sort of information at a time when we don't have probable cause. And so there is a real cost to the public and to the solving of crimes and seeking justice if the standard
Not to interrupt
were to be
you,
raised.
but I'm not asking about the level of the standard. I'm talking about the uniformity of the standard. What do you believe the impact of the lack of a uniform standard has been?
I don't see an enormous impact as a result of the lack of uniformity. In the law, we often see circuit splits and differences from one part of the country to another. We have to deal with that as law enforcement officers and as prosecutors, and so we need to follow the law in our local area. Usually those differences of opinion get worked out, and we come up with a consistent standard in due course.
Well, Mr. Dowling, are you aware of any instances in those states that the warrant requirement impeded their efforts?
I'm not aware of which states have them, which don't, and nor do I have any information for you on that.
Mr. Doucette, the state of Virginia currently requires a warrant for real-time tracking. Am I correct in that?
That is correct.
And what has been the experience in Virginia?
It's been our experience for real-time tracking that we do generally have, we have the probable cause, and we had the probable cause before, and that's why if we're looking at where someone is right now, we have reason to believe, we have probable cause to believe that they are involved in a particular criminal activity.
How would law enforcement practices change if a higher legal standard were uniformly to be adopted?
And I think that we've mentioned this, both Mr. Downing and I, is that it would have a severe impact as far as the criminal justice and the criminal prosecution provisions, where we're using this particular information to aid us in this particular investigation. And I realize this is not directly an answer to the question, but Ms. Giuliani has raised an issue about a particular case in the Fourth Circuit, United States versus Graham, which is coming up for an en banc hearing. As I understand the majority opinion in that particular case, it wasn't that they were using historical cell tower information without a probable cause determination. It was the amount of time that went on. It was 221 days that they were using this court-ordered information. And so it wasn't 1 day or 2 days. That would have been fine under the ECPA standard. It was the 221 days, and that's
Thank you for that. And I just want to give Ms. Giuliani a few moments to respond to that.
Mr. Doucette is right. In that case, there was a long amount of time, but I think it's important to note that the Department of Justice position is that even for a lengthy period of time, even for 5 months or 6 months, a warrant would not be required for historical information. And that is not consistent with what some courts have, the way some courts have assessed this issue. But like I said, this issue is still pending in many courts. There's not uniformity among states and among courts. And it's for that very reason that it's so important that we develop a uniform policy and legislation that addresses this important issue and ensures that what law enforcement is doing comports with the Fourth Amendment. And our view is that the Fourth Amendment protects Americans against law enforcement getting their information unless there is appropriate cause. And in this case, that cause is probable cause, which is a standard, but it is not a standard that is different from what law enforcement applies in a variety of circumstances when investigating many serious crimes.
Understood. And I yield back, Mr. Chairman.
Thank the gentleman. Now recognize the gentleman from Kentucky, Mr. Massey, for 5 minutes.
Thank you, Mr. Chairman. Ms. Giuliani, in your opinion, should Congress act now or wait for the Supreme Court to decide this issue?
I think that Congress should act now. We don't know when or if the Supreme Court will take this case. It could be 5 years or 10 years. And candidly, in many cases, our legal cases have lagged behind technology. And we're at a point where location information is becoming increasingly more accurate and is being collected by a wide variety of parties. Smart cards, smart medical devices. We're fairly close to having information about our location collected by these third parties. And given this, we believe that Congress can protect the rights of Americans, ensuring that location information is afforded a high level of protection, and do so in a way that is reflective of our current technological realities.
Same question, Mr. Larkin. Should we wait for the Supreme Court to decide this issue, or should we pass legislation?
You should not wait. You should look into the facts and then address the issue. In the Jones case, for example, the beeper was placed on the vehicle in 2005. The Supreme Court didn't decide the case till 2012. You can decide things a lot faster than it took the Supreme Court to resolve that issue. Secondly, whatever you decide, I think, would be well received by the Supreme Court. Justice Alito, for example, in his concurring opinion, almost pleaded with Congress to address this issue and let the cup pass from the Supreme Court. The same thing has happened in all the other cases where Congress has addressed electronic acquisition of information. The Supreme Court has been very deferential, realizing that Congress can balance considerations and has access to data it does not have.
This is a larger question, but I know that Heritage speaks to this question. Doesn't Congress lose power to the other branches when it abdicates its responsibility to legislate on these issues?
It depends on what the particular issue is, but the general answer is yes. If power not used tends to wither, and then when you try to use it later, you have a long line of precedents that people tend to point to say that you no longer have this power, you've passed it on to somebody else.
Right. That's what the late Justice Scalia told me, in fact. Mr. Downing, when we vote on this issue and legislate and amend this legislation, how many of us in the House of Representatives are going to be voting on this?
Sorry, I don't understand your question.
How many members of the House of Representatives are eligible to vote on this issue?
I believe it's 435, is that correct?
That's correct, 435. So why would you share the post-Jones memorandum with only 2? I mean, this ostensibly, whatever we legislate is going to have a profound effect on how you are allowed to interpret these issues. So why wouldn't you want Congress to be informed?
Congressman, we very much do want to have Congress be informed and want to respect the need of this committee to have the information that it legitimately needs to make its decisions. However, there are certain circumstances where particular memos contain information that if it were released publicly, or it would be detrimental to the ability of us to do our jobs. And so we seek to try to find some accommodations to allow for that.
Let me just echo what Mr. Liu said. This breeds mistrust when you don't trust Congress. And we are trusted with many other secrets of national importance. And I think the people's representatives, if not the people, at least the people's representatives, deserve to know how the laws are being interpreted and how they're going to affect them. And I would remind you that there are also 435 of us vote on your budget as well.
Thank you. We have actually done a lot to try to provide and answer any questions that the committee may have as a result of that. We've provided our public positions, which really go through all sorts of the positions that are relevant to these decisions. I've also briefed staff and answered all of their questions. We're really trying very hard to give the information to the committee.
I'd like you to try a little bit harder and give me those post-Jones memorandum. Should it be legal to turn off precise geolocation on a phone? Ms. Giuliani?
You, in fact, cannot turn off precise geolocation on your phone. Under FCC rules, all cell phones must have the ability to have GPS information. The idea of this was to provide the ability for emergency personnel to access you. But this information is routinely provided to law enforcement. Based on new regulations that the FCC has put out, they've asked carriers to increase the accuracy of this information so they could be able to assess, what floor of a building you're on.
Well, I remember in the early 2000s, I was in the tech industry. I went to a factory to get something manufactured, and they were too busy. They were retooling all the cell towers so that all of your phones could be tracked. And it was under a mandate that presumably Congress issued. And it strikes me, if this data didn't exist, we wouldn't be having this issue, or if a person had the right to turn that off. And you could see how it could easily work with a microcell, where you put this, you plug this element into the internet, and then your cell phone works magically wherever the internet is. But I know that it won't come on until the GPS finds a signal. Because of what we've done here in Congress, you are not allowed as a consumer to make a phone call unless the government is able to find out where you are. And we did all that under the pretext of safety. So, one of the suggestions I would have, Mr. Chairman, is giving some exemption to that law, allowing people to have privacy, because we're saying, well, it's not private when you share it with the third party, yet we're not even allowing you to make the phone call without sharing it with the third party. So with that, I
Thank the gentleman.
thank you. Yield back.
Now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Let me say at the outset that absent any compelling reason, I would side with the chairman, Mr. Chaffetz, and Senator Wyden in requiring a reasonable cause standard for this type of intrusion. And it would help your case, as Mr. Massey has laid out, if more members of this committee and of Congress had access to those memoranda that state your case. You're going to need it, I think. One of the differentials we have here is that Congress continues to move at a very slow pace, whereas the velocity of change in areas of technology is breathtaking. Anybody with a 16-year-old daughter understands that, cell phones are part of our personal effects now, intimately, and that the network of cell towers really does, as one of the courts described, provide a mosaic of a person's personal and private life. And I think it was not a recent case, Katz versus the United States, that says the Fourth Amendment doesn't just protect places, it protects people. And with the advent of wearable technology, the iPhone is connected to your cell phone, it's paired. So it really is, technology has really permeated our private life. One of the things I can't get beyond is in other areas of surveillance for the Department of Justice. Let's take the Foreign Intelligence Surveillance Act. We require in the FISA court that Department of Justice provide probable cause that a person is an agent of a foreign power or acting on behalf of a foreign power. So we require you to make probable cause in that case. Why would we provide a lesser standard for good old American citizens when the consequences, are not regarding terrorism or imminent threats?
I can't speak to the FISA side of the House. It's not.
We can, though. We oversee FISA. Yeah.
But I want to emphasize the way that this works is that there are many different kinds of location information. Certainly, if the access were to really precise information like the GPS information that's on the chip that was just being discussed were accessed by the Department of Justice in order to track someone and follow them around, we would indeed use a warrant.
Let me just reclaim my time, because I think you're going to use it all up. But you have access to all of that, and without proving probable cause right now. And so while you sort that all out, let me give you another example. In the FISA instance, foreign intelligence surveillance, if there's a critical, urgent need, we allow Department of Justice, the FBI, to go out in the first instance and actually conduct that surveillance if the judge is going to be shot or there's an emergency situation. In the short term, we allow them to go forward with that surveillance, but immediately, they have to go back to the FISA court and ask to verify that surveillance and to legalize that surveillance under a standard of probable cause. So they're allowed to make the surveillance, but they've got to be in front of that FISA court as soon as practicable, and they will be judged on their action by probable cause. Why would we not have that for instances that you engage in with respect to American citizens?
The answer to your question, I think, is that There are different kinds of information. Some of it is more protected and more sensitive and more
Yeah,
private than others.
I know that. You're going back to that same point again, but we have an opportunity here for probable cause for you to make your case in each and every instance. I don't buy it. We've had plenty of investigations here of the FBI acting illegally with respect to the Boston office of the FBI. We've had other situations where the FBI has overreached with, confidential informants. So the trust, and look, I know they're cleaning up their act, they're doing a good job, but we've had too many instances where a government agency has overstepped their bounds. And I think that Mr. Jordan's point about the IRS is probably, is probably a very strong example of why we should require reasonable cause.
The answer, I
Probable
think, though,
cause, excuse me.
if I may be allowed to respond, is there are situations like the Judge shooting case where we don't have probable cause. That is, we have suspects that are in the case. We'd like to be able to include them or exclude them so as to guide the investigation, but we just don't have probable cause at that stage. It's an early stage of the investigation, and having the necessary building blocks to build to probable cause is necessary. That's why we think having ability to gather information about the lesser standard, the lesser protected stuff, is actually very important.
All right, I clearly disagree, but thank you. I yield back.
Thank the gentleman. We now recognize the gentleman from North Carolina, Mr. Walker, for 5 minutes.
Thank you, Mr. Chairman. Thank you, panel, for being here today. My colleague from Kentucky, just a few minutes ago in the discussion, I believe you said that part of the problem is that you can't release this information publicly, to use your words. Congress isn't public. You also said that you and your staff have answered questions from the committee, but I'd like to go back to last October on a question that we're still waiting for. In fact, it was asked by me in asking the representative from DOJ on whether cell site stimulators to collect the content of information or communications, are you doing that before implementing its internal policy requirement warrants for the technology that you implemented in September, a month earlier?
I'm sorry, if I understand correctly, are we requiring warrants to be used in followance of the policy? Is that correct?
That's correct, yes. The witness said she was not aware of this, but would get back to us.
We do require warrants, except under those rare situations where there's an exception, like life and limb emergency.
Okay, so how many cases did you guys obtain a warrant before collecting this content?
I don't have exact numbers for, well, first of all, I would disagree whether it's content or not, but I don't have exact numbers, but the policy does require the collection of that information, and so we should be figuring that out as we go forward.
All right, so from your perspective, as far as you know, when you implemented this new policy, you guys, you're telling me, on all the components that you captured, collected, or the communications that you retained, there were warrants issued in that process.
If I'm understanding you correctly, after the policy went into effect, are we using warrants? Is that the question?
That's correct, yes.
Yes, except under those rare circumstances where the policy has an exception.
Okay, all right, fair enough. Thank you for answering that. To Mr. Larkin, I have a question for you. In your testimony, you referenced 3 reasonable arbitrary lines that Congress can draw to better protect Americans. Your second suggestion was to impose a warrant requirement if after a reasonable period of time has elapsed, the government still has a legitimate need for this geolocation information. Other than the 2 areas you mentioned, intelligence and non-law enforcement interests, my question is this: why should law enforcement not be required to obtain a warrant from the onset for the geolocation information?
There may be instances, as my panel member colleague said, where you can't satisfy probable cause, but you can satisfy reasonable suspicion. I think one thing that hasn't been adequately explained is that there is a material difference between the two. It's very difficult to try to put percentages on how right you are when you're deciding whether there's probable cause or reasonable suspicion, but it's clear that reasonable suspicion is far lower.
In your world, build me a case of when you would say a warrant's not needed here, but there's reasonable suspicion. Give me a sample situation, Mr. Downing or Mr. Larkin. What would that look like?
Well, I think his an example of someone who was shot, and you want to see, for example, based on the people who have a motive to do it, who had cell phones in that area. You don't have probable cause to believe that any one of the perhaps dozen people actually committed the crime, but you know that there are 50 people that hated someone, and you want to find out how many of those 50 were in a particular area. So you find out that information, and now you have something that you can work on that you never would have gotten if you had a probable cause requirement. And then you can go from there. One way to try to balance this out is to have only a reasonable suspicion requirement for a limited number of days at the front, and then after a certain period of time, if you thought that privacy interests demanded a probable cause showing, the probable cause showing would come into play only after a certain number of days. That would allow somebody to try to accommodate the privacy and law enforcement interests.
Mr. Downing, you want to follow up on that same idea as far as what situations, what conditions, sample-wise, would you say you wouldn't need a warrant because there's probable cause?
Actually, Mr. Larkin's explanation was far better than mine. That's exactly the kind of situation. We also have certain cases where, as another one was mentioned in my testimony, written testimony, where we just don't have probable cause yet. We have scattered pieces of information, and if we could get that extra bit of information, it might put us over the line and be able to figure out who the person is that was responsible. So it does come up, and that's going to be the burden if that source of information is.
Thank you, Mr. Chairman. I yield back.
Thank the gentleman. Now recognize the gentlewoman from Illinois, Ms. Duckworth, for 5 minutes.
Thank you, Mr. Chairman. Appropriately balancing the privacy interests of Americans against the need of law enforcement is of great concern to me. I really feel that it's a responsibility for members of Congress to provide the oversight for government interactions in the daily lives of American citizens. While I agree that a person's interest in privacy is compelling and that it should be respected, I also cannot ignore the compelling interest of law enforcement to obtain information necessary to conduct criminal investigation. Mr. Downing, the collection of cell site location data implicates both, and we've talked about this. Can you talk a little bit? If there's no uniform standard for how we collect this information, does the department have a different standard for whether the geolocation information can be obtained depending on where the target is located?
I'm sorry, I'm not sure I understand where the target is located. You mean in what part of the country?
Or situation that they may be located in. Do you have different, because there's no uniform standard, it makes it very hard to sort of pin down what we're trying to do here.
Well, of course, before the cell phone company were to disclose that information to the investigative officer, we're not going to know necessarily where that person is. In fact, that's kind of the goal of what's going on. So it wouldn't be possible to in advance say, well, we only want information about the location if it's in a certain context or otherwise. Does that answer your question?
It does, but is there any effort or any usefulness to some sort of a minimum uniform standard as you're trying to move forward with this?
Well, I think the law already provides for a minimum standard. Under the Electronic Communications Privacy Act, for example, we would have to obtain a court order with a specific and articulable facts standard. So when we're speaking of historical cell site location information in particular, it is very much the case that it is not unprotected. It's simply not quite as protected as other types of information which require a probable cause standard.
Okay. So then let's talk about once you get the information. Does the department have a consistent practice for how geolocation information is treated once it's collected, and specifically describe how that information is handled once it's been collected? If there's not a standard for what you can get, at least is there a standard for what you do with it once you get it?
So the department investigators, of course, encounter all sorts of very sensitive and private information, from personally identifiable information about people, their financial information, perhaps their medical information. So we very much respect the need to protect that information, to keep it safe and protected from disclosures, improper disclosures, and so that it's used only for the official purpose for which it's collected. Cell site location information and other location information is treated similarly with due care to make sure that it is not inadvertently disclosed.
Mr. Doucette, does your jurisdiction have similar safeguards in place when these kinds of data are being collected?
Mr. Chairman, Ms. Duckworth, in Virginia, in order for us to have real-time location data, we do require a probable cause standard. We do require a search warrant. At this point in time, given historical cell tower information, our standard is that of what is required by ECPA, that there be a reasonable standard reasonable and articulable standard before we can obtain that information through a court order. It is not that we just go and say, okay, we've made the determination that we have reasonable an articulable suspicion, and therefore phone company give us this particular information. We have to take that information before a court, and the court has to say, yes, you do, or no, you don't. And we've had these particular orders refused by courts when they say you haven't even risen to the level of reasonable articulable suspicion. So those are our standards in Virginia.
Well, what I'm concerned with is we have clear standards for how we treat physical evidence. But when you're talking about data that's gathered electronically, are there clear standards for how we handle that data, how it's tracked, how it's recorded, how it's shared, how it's preserved? When is it destroyed? All of that. Are there standards for the electronic data? Not necessarily in the same manner as physical evidence, but are there standards? And either one of you can.
There's standards. And if I understand your question correctly, are there standards as once we receive that information?
Yes, once you have the data, how do you safeguard it in the same way you safeguard physical evidence of a crime?
Obviously, we have discovery obligations, we have exculpatory evidence obligations that we do have to provide to defense counsel, and we take those quite seriously, and so we do disclose that particular information. How it gets disclosed from defense counsel then on, I have no way of controlling that. I do not release it out into the general public.
Is it available to be mined by other people on other cases that may be unrelated? Is it just, is it do you see what I'm trying to get to?
I may or may not. I mean, any information that I release in open court, obviously anybody is allowed to be in court and say, okay, this particular person's phone was in this particular location at that particular point in time.
I guess what I'm saying is, for example, I'm sorry, Mr. Chairman, I'm over time. May I just follow a little bit?
Go ahead, finish the question.
So the question is, if you get the data that you want, that like Mr. Larkin was mentioning, we want to know how many guys were in the vicinity of a crime that happened, and you get that data for this particular investigation, and it takes place. What happens to that information? Is it just sitting there for other people to come back and see who all else was there at that point in time later on, or is that evidence only used for that particular instance? I'm worried that there are not safeguards and standards in place for how that information, now that you have it, is safeguarded and used in future.
Mr. Chairman, ma'am, the answer under Virginia law is none of my files are subject to FOIA. Everything is considered a criminal investigative file under our state Freedom of Information Act, and so no one can have access to say, hit me with a FOIA request to say, what do you have, sort of thing. I do have an obligation, however, for discovery purposes and exculpatory evidence purposes to turn over to defense counsel. I do have obviously, whenever I present in open court, as far as evidence is concerned, anyone's allowed to be in that open court and say, here, what evidence we present. But that is the only way they would have access to the information that we're gathering.
I thank the gentlewoman. And to the gentlewoman's point, part of the issue is Virginia, Utah. There are very few states that actually have these things in place, and then you have agencies outside of the Department of Justice that have this tool, and such as the IRS, and nobody knows what they're doing with it, and that's the point. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman, and I really appreciate this hearing, what we're discussing today, and I share with my colleagues a great deal of concern with what we have seen in the past of abuse of government and the Fourth Amendment, and the concerns that have been brought up today, I think, are extremely valid and need answers. I would like to go a little bit more on a bit more of a practical direction at this point, and Mr. Larkin, ask you a couple of questions. Could you expand on the differences between the step-by-step traditional Fourth Amendment analysis and mosaic theory?
Sure. Mosaic theory is like a Rorschach test. You look at the entire picture and see if the entire picture is reasonable. And in deciding whether it's reasonable, one of the things you take into account is the amount of information that you acquire. If all you're doing is looking at someone over the course of one day, You may get a very different answer than if you look at it over the course of 30 days. 28 days was the number of days that was at issue in Jones, and the concern was you got a lot more information following somebody for 28 days than one, which is absolutely true. If you look at it, however, the way matters normally have been looked at, you look at each step in what the government does, analyze each one separately, and if each one separately is lawful or justified, then you don't worry about what happened at steps 1 and 2 when you're looking at step 3. And you don't worry about what happened at step 3 when you're looking at step 10. You don't ever step back and do the sort of Rorschach analysis. The problem for a court is in drawing a line. You have to draw an arbitrary line. You have to say 2 days is enough, is okay, 20 days is too much. And you have to then figure out where between those two. Congress can do that. Congress can draw arbitrary lines by deciding that at a certain point you cannot, you can go up to a certain point based on, say, reasonable suspicion, or based even on no justification at all. But we're concerned after that, so we're going to cut it off at whatever day you choose, 3, 7, or 10.
Is it a fair assumption to believe that you believe Congress should make that determination?
Yes.
Okay.
Yeah. Now, you could leave it just at reasonable suspicion throughout. That's what the department's doing now, I think, with the exception of the policy.
Fairly vague.
Right.
At that
But there is a material difference between reasonable suspicion and probable cause. The latter is much more serious. So one way you could balance this law enforcement and privacy interest is to have a cutoff period.
Okay, well, let's go with reasonable cause. From my understanding, this whole third-party doctrine issue, as I believe you mentioned earlier, has been affirmed by the courts for decades now. But as we all know, since then, technology has changed drastically. People use email now more than they do the Postal Service, for example. So in a time like this, where technology has evolved so much, do you believe that the bar for reasonable cause for privacy, has it changed, or should it have changed?
I wouldn't say that the way you define reasonable suspicion should change. What I would say is that at a certain point, you may want to say that's insufficient and that you need probable cause. Because I don't think you want to change the standards themselves, but you may decide that at a certain point, a reasonable suspicion standard allows you to accumulate so much information, you're violating the privacy of people involved.
Okay, but from a technological perspective, how do you see the changes in technology where we were all walking around with our smartphones, our emails were just, as opposed to 30, 40, 50 years ago, it was through the mail or other means. How has the changing of technology, do you believe, has it altered, or should it have altered the bar as it relates to reasonable expectations?
There's no doubt that it has. And the reason it has is, as was pointed out in, I think, Justice Alito's opinion, practicality was a basic limitation on the ability to acquire evidence in the past. Now, if you had 10 people in your police department, you couldn't do the same sort of intensive surveillance that you could if you had 10,000 people in your police department. The NYPD can do a lot more than a very small police department can. And those sorts of practicalities were, to some extent, I think, factors that courts considered in deciding how far the Fourth Amendment should go. You could say that they balance the two to some extent. Unfortunately, the historic limitation that practicality imposed no longer is with us, because the ability to collect and analyze information has so superseded the ability of any individual to do either of those that it may be necessary to re-examine the entire area.
Okay, well, thank you very much, and I yield back. Thank you.
Thank the gentleman. We'll now recognize the gentleman from North Carolina, Mr. Meadows, for 5 minutes.
Thank you, Mr. Chairman. Thank each of you for your testimony. I find myself in a very difficult spot. I don't know that I have, on many occasions, ever agreed with the ACLU. And I don't know on many occasions that I've ever gone against law enforcement. And yet, this fundamental question that we're here today addressing is, Mr. Downing, very troubling because of the expectation of privacy and what foundationally is what all Americans presume that they should enjoy. And so I guess under what scenario can you justify not sharing with members of Congress the Jones guidance? And let me caution you, because I go into a SCIF here and I see all kinds of national security secrets that I'm not allowed to divulge, and yet somehow your Jones guidance would supersede our nuclear capability in terms of my ability to see a memo.
As I've said before,
is it more important than our nuclear capability?
The department is very much interested in providing whatever information the
so you're going to provide it to all the members?
At this point, there are,
because having an
however,
interest in doing something are two different things, Mr. Downing. So are you going to provide it to the members of Congress? I get to see all kinds of national security secrets, some that you may not even get to see.
we are seeking to do an appropriate accommodation with the committee.
Appropriate according to who?
Mutually appropriate accommodation.
Well, we think it's appropriate that the entire committee should be able to see it. So
The gentleman who yield,
yes.
I don't think we should be treated any different than every other member of Congress. I've been fighting this for years. And even though we're grateful, it's amazing to me that I have to negotiate as a member of Congress, as the chairman of the committee, as somebody who also serves on the Judiciary Committee, to an accommodation. I mean, part of this deal is we're not supposed to take notes. We're not supposed to do certain things. What? Seriously? That's the reason I've resisted every other gesture thus far, is because of all these conditions. I shouldn't have to have a condition. I represent 800,000 people. They trust me to go in this republic and look at this information and keep it confidential. That we sign oaths, we abide by the law. If we don't do that, then we should prosecute us. But we see, as Mr. Meadows said, some of the most sensitive information that you can possibly have. But the guidance on post-Jones is somehow so sacred that thus far you're only granting 2 out of 535 people to go see this? It seems very inconsistent. Sorry, I yield back to the gentleman.
Go ahead, you can comment.
It's not really a matter of trust. I think that's not the right way to think about this. The department has confidentiality needs in things like the way, the positions that we're going to take. We're also worried that disclosures of one sort will be regarded later by a court as a waiver of a privilege as well. So there's a number of factors that go into this consideration.
But it is a matter of trust, because if you're saying that you can't, I mean, because we're protected in that. If members of Congress, maybe not our staff, but members of Congress would be protected. But let me go a little bit further, because what you're saying is reasonable suspicion is enough to be able to use this. Is that correct? In some cases.
For the historical cell site information, yes.
All right, so is it okay for the IRS to use reasonable suspicion as their guidance?
If what we're talking about is historical cell site information, they would have the same rules as all the other law enforcement.
All right, so let me ask you, is when we've had this whole Lois Lerner thing, and I don't normally harp on that, but they had reasonable suspicion, according to them, according to DOJ. They had reasonable suspicion. So what you're saying is they could use a stinger for every single group that they had out there that was asking for 501c4 status.
I don't have any
well, that's what they're saying. It was DOJ that we actually had a hearing the other day. So that's troubling to me that we would do that. Wouldn't it be troubling to you?
I think there should be a consistent standard for all law enforcement investigations. And the one that...
Well, the consistent standard should be probable cause, wouldn't you think, with an expectation of privacy?
There are particular situations like the shooting at the judge, though, that cause the probable cause standard to not be...
I don't know of any Tea Party group that shot anybody. Do you?
I don't.
So let's not talk about shooting of a judge and comparing it to the IRS. I mean, because you're somehow justifying that that would be appropriate.
I'm merely saying that
they can use your same standard. So what about?
It'll be one standard.
All right,
yes.
so is it breaking the law if a criminal buys a Stingray and they start to use this?
Yes, it is.
Now, why would that be? Because there's no probable cause standard.
Oh, no, whether something is a crime and whether something is available to the government under
Yeah, but here's the
standard.
difference is what you're doing is you're superseding the judicial branch by basically saying the executive branch here knows best. Because what you're saying is we don't really need probable cause and go before a judge because we have this reasonable suspicion standard.
I would emphatically disagree. It's the courts that decide this. And when we have obtained those orders, it's by going to a judge in order to obtain it, and they've signed them. And then it's litigated later. And to date, the 3 circuit courts that have decided this issue, that have not had their opinions vacated, have ruled that there is no reasonable expectation of privacy.
Here's where I would caution you, and I'm going to yield back to the chairman. This is very problematic in a bipartisan way, and you have a choice here today to start to work it where we can help law enforcement enforce it and still protect our Fourth Amendment rights, or you're going to find yourself without a tool very quickly, because I think there is a bipartisan desire here to make sure that the protection for all Americans is something that they should expect. I appreciate the patience of the chair.
The gentleman yields back. Now recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
Thank you. I want to switch a little bit more to some other ways people are tracked. We're going to start out here with Mr. Dowling, but we'll go on if someone else wants to jump in. How would justice obtain information from, say, OnStar or a similar feature that is a GPS feature built into cars about car movements?
So in the situation where there is a GPS chip in a car, or for that matter in a phone, and the company activates that chip in order to determine the location of the phone or the car and reports that back, that's a situation where we would use a search warrant, unless there were an exception to the Fourth Amendment.
Okay. Would a grand jury subpoena be sufficient?
No, not in that situation.
Okay. What would be the procedure followed to obtain real-time or prospective GPS location from an OnStar-like device, and is it different from past movements?
So, as I mentioned, a search warrant would be the type of tool that we would use when it's that kind of GPS level and collecting it prospectively. I don't believe that OnStar collects historical location information. I'm not familiar with that.
Okay. Can you have a service provider send real-time data location from the device's GPS?
Like, if you're asking if it's a real-time collection of that GPS information, that would be, as I said, with a search warrant to the provider.
Okay. I'll yield the remainder of my time.
Before he yields, let me, if the gentleman will yield, just to kind of follow up on that, can the government have them turn on the GPS device in a car?
Yes, I believe that in many ways a car GPS device of that sort is very similar to a cell phone. And there are some of the companies, I don't know about OnStar in particular, that have that capability the same way that some cell phone companies do.
Ms. Giuliani, can you give us your perspective on that?
You know, I think that,
Sorry, your microphone.
you know, one of the things that's been particularly concerning to us is, you know, as I understand it, part of the reason that the Department of Justice believes that a probable cause standard is not the appropriate one is this idea that, you know, individuals have voluntarily provided this information. And that's certainly not true in the cell phone context, where most of us, you know, are not aware of the information that phone carriers collect. And when it comes to GPS information, don't really have an ability to turn that feature off. And I think whether it's OnStar, whether it's the medical devices of the future, the ability to turn that information off may not exist. And the idea that law enforcement can, you know, in some cases ping the device or remotely turn on the device and capture our location information when we are not aware, we wouldn't want it captured, and do so potentially without appropriate protections is very concerning and doesn't comport what the Fourth Amendment would require in this context.
Go ahead and assume that the gentleman from Wisconsin yields back, and then I'll recognize myself, and then Mr. Cummings as we wrap up here. We've been talking a lot about the federal, Department of Justice. Mr. Downing, the positions that you represent, is that true throughout all of the Department of Justice? Is it specific to just the criminal division which you represent? Are we to assume that this includes the DEA and the marshals and the FBI, et cetera?
The positions that I've been discussing apply across the board to all criminal investigations. I can't speak for national security investigations.
Okay. Just want to make sure I understand the scope. And what's also important for those listening to this hearing and members is that's just the Department of Justice, and the concern is that other departments have their own standards, their own way of collecting and securing these data. As Ms. Duckworth talked about, one of my concerns is what are the standards? Because if you're going back, not having to use a warrant to gather historical information, there's no bounds on that. If you knew that some political group or organization was meeting at a certain location at a certain time, you could go get all that information and not have to get a warrant, correct, Ms. Giuliani?
That's correct, and I think even more concerning is that there's no notice. So, for example, if you're in a situation where the Department of Justice or another law enforcement agency is collecting information about hundreds of individuals and what cell tower they connected to, it's not the case that after 90 days or the conclusion of the investigation that you'll be provided notification and be able to challenge that conduct in court. And that's different than the approach taken, for example, by the wiretap statute. And so what we've essentially got is a situation where innocent people who have their information collected, as a practical matter, just don't have recourse to challenge this conduct in court.
The ACLU did a very interesting report. I can't remember the date of it, but I was fascinated by it. It's part of what compelled my interest in this topic, where you did a survey across the nation of the various law enforcement. I believe it was municipal, county, and state law enforcement. Can you generalize that? And I would ask unanimous consent to enter into the record. Although I don't have it here, I'll get it in the next 2 days. Without objection, so ordered. But Ms. Giuliani, can you give us the framework of that survey?
Sure. We've done 2 surveys. One was we filed FOIA requests with law enforcement jurisdictions across the country to ask, whether they're using collecting location information, and if so, what standards apply. And what we found was, by and large, most law enforcement agencies were collecting this location information, but that standards differed widely. So in some cases, jurisdictions such as those in Kentucky and Hawaii had voluntarily decided to follow a probable cause standard. In others, we found that jurisdictions were following a lower standard or not requiring a warrant. As part of that report, one of the things that we found was that despite Department of Justice policy that states that a warrant should be required for real-time prospective collection, in both New Jersey and Florida, it appeared that there had been cases where location information had been collected without a warrant. So that was one report we've done. The second examination we've done is we've also conducted FOIA requests on the use of stingrays, these cell site simulators which can collect massive amounts of information. And what we found is, despite the fact that there are no federal laws, no federal guidance, even concerning localities that receive federal funds to purchase stingrays, that also the standard varied widely. In some cases, law enforcement were not getting any court authorization. In other cases, even in cases where they received court authorization, they weren't informing judges, hey, this is what we're using, this is the impact of what it has. So judges were in some senses blindly, signing orders. And the third thing that we found was that there had been a concerted effort to keep these devices secret from both judges and defense attorneys and the public. And so the Department of Justice signs non-disclosure agreements with states and localities who purchase these devices. And those non-disclosure agreements say that information cannot be released. And there may be cases where, in lieu of releasing information to a judge, the state or locality is suggested to drop the case or offer a plea bargain. And that was particularly concerning to us because, as we see it, the courts represent a way to provide oversight of the use of these devices. And to the extent that there is a concerted effort to keep them secret from even these entities, that is a loss to the American people.
So going back, Mr. Downing, the Department of Justice has these non-disclosure agreements, cell site simulator non-disclosure agreements with state and local law enforcement. Is that something you can provide to this committee?
Yes, we can provide those. I would note, though, that the approach that we've taken, particularly following the cell site simulator policy, is to make clear that we are not trying to conceal, and nor should that policy be implied, to conceal the fact that a cell site simulator was used, and that, of course, there's always an obligation of candor to the court. At this point, the FBI is actually looking again at those non-disclosure agreements and is in the process of revising them, trying to clarify what the approach is now.
Why the change?
Well, I don't know that I have all the factors, but certainly when the environment has changed, there's certainly a lot more information publicly available about these devices. And when the department did an analysis of looking at this whole situation, we decided to institute the policy in the end, and now we're trying to make sure that all of our practices are consistent with that policy.
Now I recognize the ranking member.
Ms. Giuliani, you, as I was just listening to you, it sounds like different standards or no standards all over the place. Is that right?
That's exactly right. There's different standards among states. There's different standards, as you've heard, between types of location information. And there's different standards that appears from even how you collect that information, whether it's a stingray or whether it's through a phone carrier.
So would you agree that we have a serious equal protection issue here?
I think there are serious concerns that, depending on where you live or the type of technique being used, that you will have a different standard apply, which is one of the reasons we believe it's so important that we have legislation, or at a minimum, that the average American has information from the Department of Justice as to what standard actually applies. What standard applies when they're collecting historical location information from a phone carrier versus the information that might be collected from, say, a phone app. Those are all missing pieces where the public, and it appears in some cases members of Congress, have been left in the dark.
Mr. Downing, as listening to the other members of the committee and the chairman, it is good that we were able to reach an agreement, but if I were another member, I'd be very upset. I'll be frank with you. I mean, we all represent approximately the same amount of people. And I think they made reasonable arguments that we are entrusted with all kinds of very sensitive information. And I'm hoping that we can, I know we've reached our agreement, but I hope that we can revisit that because I think it is unfair to members, but particularly with something as sensitive as this. It affects almost every single person, am I right, Ms. Giuliani, in this country?
Almost every American has a cell phone.
And we represent them. And I think the public would be alarmed if they knew that there was such a memo apparently giving guidance and their members could not see it. I mean, it just strikes me as just not, something is not right there. And that's after, the chairman will tell you, we try to reach a balance, but it seems to me like this is kind of not balanced. But thank you all for your testimony. I really appreciate you.
As we conclude here, I just want to kind of go down the panel, just take 30 seconds or so if you have any concluding thought. I wasn't able to let all panel members answer all questions, so if there's something you want to share verbally here, and again, we would always welcome your ongoing communication and input and thoughts. But let's start with Mr. Downing and kind of go down the line, and then we'll conclude this hearing.
Just in closing, I've heard a lot of talk about whether there's a need for legislation. Obviously, we don't have a position. On particular legislation, but I would encourage the members of the committee to think about the different kinds of location information there are, and can consider whether there are different balances that need to be struck between those different kinds, taking into account the needs of public safety and the justice system. And we look forward to working with the committee as that process moves forward.
No, and look, we have a duty and obligation to help keep the public safe, but I would also argue that we're different in the United States of America. We are more open and transparent and critical, and part of my frustration is not the good work that you and so many of the men and women at the Department of Justice do. It's just that in order to try to craft the right solution, if we don't see all the facts, we're going to come to the wrong conclusion. And Congress is notorious for coming up with wrong conclusions. So we are trying to get it right, and having the maximum information helps us to get there. And that's the spirit in which we approach this. So thank you personally for your commitment to this country and all that you do. And thanks for being here today. Mr. Doucette.
Thank you, Mr. Chairman. One of the questions that was asked during the course of today's hearings was dealing with who should act, whether it should be Congress or the courts, and who can act most quickly in order to deal with the changing technology. I think the answer is clearly that this particular body can act more quickly as the technology change. But that's not my original thought. That's Justice Alito in his concurrence in United States versus Jones certainly suggested that. That concurrence also brought up the concept that Mr. Heiss was asking the questions about the mosaic theory, and that's certainly the topic of a law review article written by Professor Oren Kerr of the George Washington University School of Law. It's a fascinating article. The problem that is raised by the mosaic theory and that Professor Kerr raises is that, just as Mr. Larkin has pointed out, at what point in time does what is not a violation of a Fourth Amendment become a violation of the Fourth Amendment? And I think that obviously if Congress is going to act and should act in this particular matter and can act in a number of different ways, saying that historic cell tower information needs a probable cause determination or doesn't need a probable cause determination, or finds the middle ground that Mr. Larkin was suggesting, perhaps as far as his second alternative, is that maybe at some point in time, whether it's 5, 10 days, what has been justified by a reasonable articulable suspicion converts over to a probable cause determination. That would aid us tremendously in guiding law enforcement and guiding the courts as to how to apply the standard for historic cell tower information. I thank you for the opportunity to address this body.
Thank you. And again, thanks for your good work, and thanks for your expertise in being here today. I do appreciate it. Mr. Larkin.
3 brief points. First, several members asked, what is the adverse effect from a search warrant requirement? I think the right answer to that is we don't know. We don't know in individual cases because no individual police officer or agent is going to be able to say the reason I couldn't make an arrest was I had to use a probable cause standard rather than a reasonable suspicion standard. Plus, at a macro level, we don't have anybody collecting that information on individual cases. So we really don't know the answer to what is the adverse effect from a search warrant requirement. Second, with respect to the post-Jones memo, there isn't a good argument why DOJ shouldn't share it. It's, I think, a historic artifact. I was at DOJ for 9 years, and the executive branch and DOJ tend to look at Congress as not being part of the government. Congress has always taken the position that the attorney-client privilege, for example, doesn't apply between the branches because it's all one government. The same is true here, and certainly, as your colleague said, if you can get information dealing with the government's nuclear capabilities, you can get information dealing with stingrays. Finally, your colleague from Wisconsin, I think, asked about OnStar. OnStar is a private company. The relationship OnStar has with a customer, whether it's Ford or John Doe who buys a Ford with OnStar, is not governed by the Constitution. There may be federal statutes that regulate to whom OnStar can give that location information, but the Constitution doesn't come into play at all. So if there's no statute limiting what OnStar can do, OnStar can give that information to the New York Times if it wants. So what happens when you regulate the government is different than private parties.
Well said, and again, thank you, Mr. Larkin, for your expertise and your participation here today. We do appreciate it.
Thank you, sir.
Ms. Giuliani.
Well, thank you very much for having this hearing. I would underscore, the points I made earlier. I think that now the time is ripe for congressional action here and for legislation, and for holding law enforcement to the same standard that applies to information in a variety of other contexts. Whether it's entering your home or getting a letter, and a probable cause standard. I would say, though, in the interim, as we wait for such legislation, I know that members of the committee will continue to press, and I hope that they will press the Department of Justice to release its policies publicly. I appreciate the fact that members of this committee will now have an opportunity to see the Jones memos. That's an opportunity that all Americans should have. And we should also understand exactly what standards are governing collection of location information. And to the extent that the Department of Justice can release a policy, similar to what it did with stingrays, release a public policy so that Americans can understand what standard applies, and we hope that that policy will have a probable cause standard. And we think that it should have a probable cause standard to comport with the Fourth Amendment. And without such actions, I think we risk being in a place where, simply due to modern technology, the fact that I want to use a cell phone or I want to have a GPS system in my car, that somehow I'm entitled to less privacy. Somehow my life is an open book in a way that the founders didn't intend. And given these technological realities, I certainly hope that Congress will press the Department of Justice to take these actions.
Thank you. You've been very insightful and very helpful on this, Ms. Giuliani, and I do appreciate your participation and your insight, your help with this committee. So thank you so much for being here. Thank you all. The committee stands adjourned.
Nicely done.